Lori Anderson versus Armani Lyman.
Hi, Judge.
Hello, Miss Anderson.
All right. On advice of counsel, I wanted to cancel this matter.
You want to dismiss it?
Yes, sir.
Case is dismissed without prejudice.
Thank you.
Thank you. That's it for that block. Yay, we're back on track. All right.
A routine morning in a courtroom. Cases get called, dismissed, moved along, the machinery of justice grinding forward at its usual pace. Nothing unusual, nothing alarming, just another day on the docket. But what happens next is anything but routine. Because buried inside this courtroom session are two cases that will force a judge to make decisions that no amount of legal training truly prepares you for. Cases where the law collides head-on with human desperation, addiction, and one moment so shocking even the judge struggles to find words. Sit tight. This courtroom is about to get very uncomfortable.
Courthouse case, People versus Lewis McSwain.
Trovius Starr, standing in for the attorney of record, Mr. William Amadeo, on behalf of Mr. McSwain. Mr. McSwain, state your name.
Lewis McSwain. Get hands out here.
Your Honor, two things here. First, Mr. Amadeo has informed me that he has not received discovery yet, so he's asking for an adjournment. And then secondly, it's my understanding that there's a community corrections violation for positive for opioids.
And cocaine.
And cocaine. Okay.
So that you know, there's on April 10th, he was positive for cocaine and opiates.
3 drug tests, 3 red flags, and a defendant who just walked out of jail directly into a pattern that community corrections can no longer ignore. Cocaine on April 10th, a suspiciously diluted sample. On the 17th, the kind of move that screams someone knows exactly what they're doing, and then opiates again on the 23rd. This is not the story of someone stumbling. This is the story of someone who has been to the system enough times to know how to play it, or at least try to. The question now isn't just what was in his system. The question is whether there's any explanation that a judge is actually going to believe. And the defense attorney is about to walk up to the bench with something. A prescription. The kind of detail that could either save a client or make everything dramatically worse.
That's when I first got out.
On the 17th, a week later, there's no drugs found, but he has diluted his creatinine. So he watered the test and it comes back with diluted creatinine levels. But then by the 23rd, about 6 days later, the opiates are back.
That's correct, Your Honor. I think that for the 10th, the defendant had just gotten out of jail after being arrested. So there was nothing to indicate that abuse may have been while he was on bond. However, the court is asking to the correct of the 17th with diluted creatinine as well as the 23rd with the positive opiates. I am aware that there's a prescription that Mr. Starr showed me for hydrocodone that's prescribed to the defendant. However, the date of that prescription that I saw on there, I mean, there's a new one, April 29th.
April 29th of
2026.
Your Honor, if I may, my client hasn't, well, Mr. Amadeo's client has informed me that he's been receiving the script, if I could approach, for 2 months now. And he can go back and show prior scripts. May I approach?
Yeah.
There's 3 different prescriptions on there.
Okay, I see that, but
The last one is for hydrocodone.
This is from the 29th.
Correct. He informed me that he can go back and get those prior scripts. A letter from his doctor as well to show that he's been receiving this now for 2 months. So the
So he's getting them filled at Walgreens?
Yes.
I'm sorry, what was the question?
Does he always get them filled at Walgreens?
So they're Walgreens, other places.
Yes, other place. A little closer.
It varies in terms of the place he picks up his prescription. But he can get a letter from his doctor stating the initial date that he was prescribed hydrocodone.
Well, I think somebody better go find that, because all I have in front of me is a positive test, and a prescription after that date. I don't have anything on these indicating.
I didn't have no way. When I got out, I had already been taking them, so I don't know, keep this.
And
Here's where the math stops adding up. The first failed drug test was April 10th. The prescription on the table is dated April 29th. That's 19 days after the positive result, not before it. And instead of one prescription, they brought 3, but none of them are refills. 3 new prescriptions, no refills, no prior documentation, and a story about forgetting to keep old paperwork. The judge is sharp. She's not missing a single detail, and you can hear it in her voice, controlled, measured, but the skepticism is building like pressure behind a dam. Because a defendant in a drug delivery and manufacturing case testing positive for the very substance he allegedly sells, that's not a coincidence. A prescription note easily explains away. The prosecution's about to make sure the court understands exactly what kind of case this really is, and when they do, the temperature in that courtroom drops several degrees.
it's interesting also to me that, well, let's see, make sure I'm saying this right, which would be typical that these aren't refills.
I also think I noticed that, Your Honor.
So,
And it would be the request of the people, just to make the record clear, that the defendant be remanded at this point and his bond be revoked. This is his 3rd test that he's given, and the 2 that would have been when he was on bond, neither of them are acceptable or negative. It's also my understanding when someone does an intake with community corrections, they're understanding prescriptions. They understand that people may prescribe things that will come up on their test, and I don't have an indication that you let me know that the defendant had that conversation with community corrections. It's oftentimes the case that they will say to the effect of, we are aware this person is prescribed buprenorphine, we're aware that they're prescribed any variety of things that may be positive on the test. The court in this case, I don't know if you've had an opportunity to review the charging documents, but this is a delivery and manufacture case. Okay, so this is a case where we have somebody that's manufacturing or delivering controlled substances, and he's now testing positive for opiates. I'm extremely concerned and would request that bond be revoked, he be remanded.
Your Honor, I'm asking at this time, just for right now, that you not do that. If you could allow me some time to possibly get in contact with his doctor so we can get this squared away. He has a prescription for hydrocodone. That's there. He's informed me.
prescription though is after the date of actually both of these. Actually, the first test and the after the date of all of his testing.
Yes, the prescription that we have right now. That's why I'm asking right now, just for this moment, right now, if you not do that to allow me to clear this all up. I was just informed about this. It's not my case.
So let me ask this.
And also, too, one more thing. He does not.
Okay, go ahead. Interrupt me.
Okay, I'm sorry.
No, go ahead. What do you want to say?
My client has informed me that he does not have a supervisor, an agent at community
I
corrections.
was trying to bring him that and tell him. Because the warrant came out after I had.
What do you mean he doesn't have one?
He has no one that he goes and speaks with directly.
I just paid my money and
You can speak up. You can speak up.
I just paid my money and drive.
He pays his money and drops a sample. No assigned officer, no supervisor, no one checking in with him face to face, even slipping through the cracks of the system. And somehow, that fact is both his best defense and the most troubling detail in the room. Because if no one is watching, who exactly is supposed to catch this? The attorney standing in today is not even the attorney of record. He's covering someone else's case, handed this mess without full context, trying to hold back a flood with his bare hands. And yet he keeps asking for just 15 minutes. 15 minutes to make a phone call, to find a prior prescription, to build a bridge between what the paper says and what his client is claiming. But the judge has heard this before, and the clock is ticking louder than anyone's promises.
I was trying to bring it to anybody's attention, but they said they don't have nobody.
So I'm asking if you could pass this matter and allow me to.
Here's my question. Why does he have these today?
Because he's been trying to inform people that, hey, I'm taking these medications, and which one of them is an opioid. So he brought it to court. He did this, instead of leaving it at home, he did the smart thing and brought it with him. Instead of
Knew he had a positive test.
yes, because he's been taking opioids. And that's the part where I'm asking if we can pause this matter so I can look further into this, so I can shell this out.
What does Bellinger want to say?
Your Honor, I would so too ask that this matter get passed for a few moments. I do have some information that I can share with the attorney that may or may not be helpful to at least past use of Norcos with the client.
I'm just asking if we can pass this matter for right now. I'm not even asking,
I want to know. Hey, certainly, Mr. Bellinger, I'll let you talk with counsel, but I'm trying to figure out why did he bring these today and not the previous ones?
It's been my experience, Your Honor. Been doing this now for 11 years. I've come. Yes. Wow. Congratulations, Tro. Yeah.
11 years.
I've come across plenty of clients who
Like
say, "Oh, I have
For the time that's like 1/20th of the time Vincent's.
I have a prescription," and then I ask, "Where's the prescription?" "Oh, I left it at home." He brought it with him. He's been trying to get someone to see, "Hey, I have a prescription for these things." He hasn't been able to see anyone at community corrections to show them.
Where's the previous prescription?
That's why I want to look into. That's why I'm saying if we can pass this right now.
What I'm trying to figure out is why he didn't bring that one, because this one is problematic because it's all after his testing.
No, I didn't have. Oh, you knew. They tell they called, but I'm saying for the brand when it wasn't on any papers like.
Your Honor,
And none of the
answer your question.
Cocaine. But anyway, go ahead.
But that was, I believe, when he got released. But to answer your question, why did he bring this? Community corrections called them and informed them, "Hey, positive test." So he brought that. He brought the current prescription. Again, I've come across plenty of clients who say, "Oh, I have a prescription. Where is it? I left it at home. I can't find it." He brought something. I'm asking, based off of that something, if I can go and look further into it just for right now.
For how long?
10, 15 minutes.
Okay, then at this point, his bond's revoked. They can take him, and then we'll bring him back out if necessary.
May I approach?
If you want to, but I don't know if you do.
Previous prescription. I didn't have to keep because there wasn't a warrant out for my arrest for this case. So I had no reason to keep it. I wasn't reporting to anybody. So when the warrant came out, that's when I was, and now I got to start keeping them. But prior to that, I never had a warrant, so I never had to keep them.
Oh, okay. All right. Thank you.
Bond revoked. Just like that. 15 minutes wasn't enough, and maybe the judge had already made up her mind the moment she saw 3 prescriptions with no refills and dates that told the wrong story. The defendant will sit in custody while his attorney scrambles to find paperwork that may or may not exist, but the courtroom doesn't pause for any of it. There are more names on the docket, more cases to call. And the next one, State versus Ashley Treat, is about to deliver the most jaw-dropping moment of the entire session. No one in that room is ready for what's coming.
I don't know yet. I'm going to give him 50 to what he's got to do. Court calls case People versus Ashley Treat.
That's about 6 people.
And Laura Yaki, Assistant Public Defender, with and on behalf of Ms. Threet, who's approaching. Ms. Threet, could you state your name for the court?
Absolutely.
So, Your Honor, within the last couple days, Ms. Threet has sought an assessment for treatment. She completed the assessment. I have the paperwork here. I have the letter here. Based on the assessment, she's been recommended to participate in the intensive outpatient program through Henry Ford Health. Going to have this documentation here. She is scheduled to attend individual treatment on the 2 days that she's not doing her intensive outpatient program, which is scheduled for 3 days per week. Additionally, Ms. Fleet is doing meetings every single day as a part of her recovery. I would ask, Your Honor, obviously the bond violation is very concerning, is very serious.
Okay, yeah, go ahead. I'll listen to everything, but
I would ask if the court would consider converting her SoberLink to a scram tether to ensure that she's getting 24/7 supervision, monitoring to ensure she's not drinking.
Jackie, you do realize that not only did she blow numbers, but then decided to have someone else blow into the machine for her.
A SoberLink is one of the most straightforward tools in a court's arsenal. Breathalyze, confirm, continue. It only fails when someone actively works to defeat it. And defeating it requires a choice. A deliberate, calculated, fully conscious decision to cheat the system on bond for a serious offense. But the attorney keeps going. Treatment plan. Psychiatrist. Therapist. 3 days a week of intensive outpatient. Meetings every single day. The picture being painted is of someone fighting hard for her recovery, desperate to change, worthy of another chance. It's compelling. It's thorough. It's exactly what a good defense attorney is supposed to present. And then the judge stops the room cold, because she knows something the attorney either doesn't know, or is very carefully not saying out loud.
Yes, Your Honor. There's no minimizing. There's no excuse or justification. The only thing I can do is present our plan moving forward, which the therapist has a psychiatrist. She does have mental health diagnoses. So she does need medication. She has her psychiatrist she's working with. She has her therapist she's working with. It took her a minute to find the right treatment to address the needs that she has. She is a single parent of 2 kids. They do rely on her tremendously. One is 3, one is 13, I believe. And
So even worse, she had a 13-year-old blow into the machine?
Well,
I didn't ask her to she's free.
Oh, whoa. Is that what happened?
I didn't.
Be careful how you answer it. I don't know that there's a good answer, but you better be careful how you answer it. Because I don't know which is worse. You telling me that, yes, is that what I did, or you lying to me?
I at this time, Your Honor, I'm asking if the court would convert her to a scram tether and mandate that she
drank and then had a child blow into the SoberLink.
I understand that's what the violation report says, Your Honor. And
does she admit to that violation or not? I mean, if she wants a hearing, we'll have a hearing.
I understand. May I have a moment to verify with her, Your Honor?
Yep.
She used her 13-year-old child to blow into a breathalyzer so she could fake her sobriety reading, let that land for a moment. Not a stranger, not an adult friend. Her own child, a minor, in a house where she is the only parent, the only protector, the only responsible adult in the room. The judge's voice tightens. Be careful how you answer it. I don't know which is worse. It's not courtroom theatrics. It's a judge genuinely wrestling with what she's hearing because both possibilities are bad. Either the attorney just exposed her client without realizing it, or the judge was lied to and she knows it. In 13 years of courtroom observation, most legal professionals will tell you they've seen addiction do terrible things to people. But weaponizing a child to evade judicial oversight crosses into territory that no treatment plan or trauma history can simply paper over.
Your Honor, may we briefly approach?
I don't know what good it's going to do, but you can come on. Record should reflect we've had a bench conference in this case. Just want to say, Michelle.
The only other thing I wanted to request that I forgot to mention at the bench conference is if the court is inclined to revoke her bond, I would ask if there's any chance the court would allow her to be released to an inpatient treatment program with the tether, as clearly the root cause of both the underlying case as well as the bond is an issue of substance use. Again, she has dealt with enormous trauma. She's a survivor of domestic violence. She left an abusive relationship where her ex was convicted. And I think in November or shortly before December, which is the alleged offense date here. So there's a lot of circumstances surrounding here. Understandable that the court and the people are concerned for the community, but I would ask that this not be a case just held in jail without the opportunity to get inpatient treatment.
Ms. Valtes.
Your Honor, the people at this time would request the court revoke the defendant's bond and do not grant her a release to treatment. The underlying offense in this case is an operating while intoxicated third offense. Her priors are from 2011 and 2016. In this case, there was more than one call to the police reporting the defendant's bad driving behavior. She was eventually located by Michigan State Police troopers, crashed, and when they had contact with her, she admitted to drinking. Eventually, a search warrant was obtained for her blood, and she was found to have a blood alcohol content, of 0.258. She was incredibly intoxicating, putting the community at risk, and is now drinking on bond. And as the court correctly pointed out, having a 13-year-old child flow into that sober link. I do not think she is in a position where she's capable of making good decisions, and I do not think that she is a risk the community can tolerate. I'm asking both the bond, hold her without bond, deny her a release.
Anything else, Ms. Carter?
Your Honor, the only other thing I would say is I do think it would be adequate to protect the community if she's not driving, if she has a scram, if she's in treatment, especially if she can't leave.
0.258. That's more than 3 times the legal limit. Crashed. Admitted to drinking on the scene. And then later on bond, drinking again and recruiting her own child to help hide it. The prosecution's argument isn't just about numbers on a breathalyzer. It's about a pattern. A pattern of choices made over years, across multiple priors, that place other people in danger every single time. The defense attorney fights hard. She brings trauma, she brings context, she brings a treatment plan that's genuinely thoughtful. And none of it is wrong. Addiction rooted in domestic violence and untreated mental illness is a real and serious thing. But the judge has to weigh all of it against one undeniable fact. When given the tools and the trust and the freedom to make better choices, something very different happened instead. There's a reason courts don't make these decisions lightly. Because on one side of the scale is a woman who needs help, and on the other side, an innocent community and a 13-year-old child who deserves none of this.
I can't trust her. I'm just going to be upfront. It is going to be very hard for me to trust somebody that this court releases on a sober link, can't comply with the sober link, drinks, and then to try to save herself because she knows she has to do the confirmation below. She puts a child to do that. Incredible. I will adjourn our probable cause conference May 14, 2026, 9 a.m. I'll also adjourn, since there's no admission or anything regarding the bond violation. I'll adjourn the bond violation hearing to also that date. At this point in time, the defendant's bond is revoked. Defendant's remanded to the washroom.
Incredible. One word. And in that one word, a judge said everything that needed to be said. Bond revoked. Defendant remanded. The courtroom moves on, as courtrooms always do. Another case called, another name read into the record. But these two cases leave something in the air that doesn't dissipate so easily, because they aren't just legal proceedings. They are windows into the lives of people caught in the spiral of addiction, desperation, and the choices that spiral demands. Some of those choices are understandable. Some are forgivable. And some, like putting a child in front of a breathalyzer to cover your drinking, cross a line that a judge, a prosecutor, or any reasonable human being simply cannot walk back across. Justice isn't always clean. It isn't always satisfying, but today in this courtroom it showed up, and it did its job. Thanks for watching. Video like and subscribe for more videos.